Hi, welcome to Esquire TV. My name is Zafia Parker. I'm an attorney here, and we're having a discussion about Facebook, media, social networking, and the law. Today's topic is social network and litigation. And really to my right is Professor Leonard Baines from St. John's University Law School. Good afternoon, Professor.
Hi.
Professor Baines teaches communications in the law, and he'll be discussing employment law and Facebook's and MySpace effect on that. Immediately to my left is Tanya Blocker.
Hi, how are you?
She will be discussing family law and how it's been affected by Facebook. She's a second-year associate at one of the firms here in Manhattan. And I have Eli Babayev here, who will be discussing civil practice and Facebook's effect on that.
Good afternoon.
We're here at Hotel 41. It's a lovely restaurant here at Times Square. And we're having a conversation about Facebook and the law. Our first topic of discussion, in general, its effect. You've all heard in the news that employers are looking at their employees' Facebook pages, and people are actually losing their jobs. But what you probably don't know is that it's spanned bigger than that. Universities are checking out prospective students' Facebook pages as well, decide they should admit them. Jurors for cases are being selected by jury selection by what they write on their Facebook pages. Divorce proceedings, custody battles, criminal prosecutions, all are starting to use Facebook, the social media, to decide how they should further their cases. We're here to really examine the constitutional ramifications of that, the expectations of privacy, and how the law should deal with this new emerging technology. Professor Baines, do you have any comments you'd like to say in general?
I think that part of the issue is that there is a blurring of the walls between privacy and public, the private and public, and that many people think, oh, there's this thing that I can have fun and I can link to all my friends, but they don't realize that that kind of information can be used for a variety of different circumstances. So for instance, in terms of admissions to law school or colleges or even employment, it's often become very standard practice for employers or admissions offices to look at Facebook pages. And so you have to be careful what's on your Facebook page. You have to be careful what your friends are putting, what pictures are there in terms of presenting the kind of image. It's not like before where, if you were showing friends or jokes with your friends in a private setting where no one would know what that is. Now everybody knows what that is. The pictures of you with the lampshade on your head or whatnot, or the beach scene, or the revealing clothing, all that sort of stuff is there, and people are going to make judgments about it.
Well, I think what's also very interesting with respect to just the privacy settings on Facebook, and let's say employers or schools actually looking into what these students, for example, or employees or potential employees are doing. It's not as if they see a page that's private, they Google the name, it comes up, they see the page that's private, and then they try to see if any of their employees or other individuals are actually friends with those individuals. Now that I can say, you're taking a step beyond, this is something I specifically made private, that you're actually putting out there to, actually try to invade my privacy to some extent. However, when you have something in the public domain, you actually put it out there. You cannot now choose or restrict who sees it and who doesn't see it. If you can Google my name and this information comes up, I can't say, oh, I want Zafia to see that information, but I don't want Professor Baines to see that information. I mean, that you have to take that in consideration when you're putting these things out there on the internet.
And just to jump off of that, Tanya, I think you make a great point. Just to give a personal war story, I was defending a municipality at one point, and it was in Queens County, and the case was of a student who claimed to have injured his hand when he put his hand through glass in a door. And I Googled his name to see his history, to see what this kid is about, and his MySpace page came up. And one of the photos on his MySpace page that were posted there, it was public. I didn't have to put in any password in order to see it. It was actually the injuries to his hand. But although he said that he pushed the door open with his palm during his deposition and throughout the court proceeding, you could see that the cuts were to his fist, and he was actually making these remarks about how he punched the door with his fist. So my whole theory at trial was to the jury, this is not a innocent young boy who accidentally cut himself by pushing the door with his palm. This kid was mad and he punched the door with his fist, causing his own injuries. And I wouldn't have had that theory if I hadn't Googled him and had access to his MySpace page, which was public access. You didn't have to put in any password.
So you use his own statements to impeach him.
Exactly. Not only his own statements, but seeing the photo actually put the theory of my case in perspective with the jury, and ultimately the jury agreed with me. It was a defense verdict.
So,
On a broader question, how do we advise clients about tailoring their page? Let's say a civil litigation started, and your injuries might not be consistent with what you have on your Facebook page. Ethically, do we advise them to adapt it, to leave it alone? What can we do? And I think about Facebook too is it kind of has a cloud technology. What do I mean by that? It's really your personal computer, your personal diary that goes to every computer that can spread to any amount of people that you want it to. So do we have an obligation now as attorneys practicing in 2011 to tell people what to put on there, when to take it off, or leave it alone?
Well, they didn't cover that in my ethics course when I was in school. This is all relatively new, so but just common sense, commonsensical, just tells me, an attorney cannot advise somebody to delete photos from their Facebook page because they're starting litigation that can be contrary to what they're suing for. That's just common sense to me that an attorney is not allowed to do that. But however, I would advise my client, if I had a client who pursued litigation, I don't know if this is unethical or not, but I would advise my client, make sure your Facebook page is private. Make sure that not everybody could see it. Put it password protected somehow, so not everybody has access to it.
And certainly make sure that you don't put these things up there, right? That's the start from start one. Is don't do it is basically the number thing. I think there probably is an ethical issue, certainly if you start litigation, to delete it. And plus, things are never really fully deleted. That's the challenge. Right. And so, if you say you're deleting it, it's somewhere. Somebody has it. The Facebook itself may have it. Somebody probably can gain access to it. And then once you've deleted it, then that seems almost like someone could use that as an admission. That, if they find it, that look, he's trying to obstruct justice or thwart the investigation in some sort of way. So I think it's the bottom line is that we need to do, as more than lawyers, we need to do as a society a better job of teaching people what they need to do with respect to Facebook pages, how to handle it in a responsible manner.
I also think as a attorney representing a client, in addition, you need to know what this client has on their Facebook. Ultimately, you can advise them keep your page private, but if we have a case like we just recently had that we talked about in Suffolk County, where they were allowed access to this private page, then we need to inform our clients as our duty of proper investigation to say, what is it on your Facebook page? I may need access to your Facebook page to know what it is that we're fighting against to some extent with respect to discovery, if we can actually get it excluded at all.
I think that's a good point, and letting people know that it's actually becoming standard practice to change it, to check it, to investigate people's pages, their Twitter accounts, their MySpace and their Facebook. Criminal prosecutions, attorney general offices, they're using it when they want to prosecute people. They're constantly investigating their pages, trying to show intent. Recently there was a high-profile Casey Anthony case. Child was missing for 30 days. How did they show their intent? The prosecutor's office used her Facebook page comments to show how she was partying and having a good time while her child was missing. It's actually being used to show intent. And so I think because it's becoming standard practice in criminal prosecutions, we need to be able as attorneys to let people know that this will be checked and you need to be prepared for it. It also has an effect in family law as well.
Absolutely. Many cases and many attorneys, as I've done my research, have actually, in divorce as well as child custody cases, have used Facebook as their primary source of evidence. Even saving and hiring a private investigator or investigators to even investigate cases, Facebook is their primary source of evidence. One particular case in which a young lady was married, and they posted this on Facebook, and then the young lady got married, the young man rather got married again. And the controversy was, the case was more so like bigamy on Facebook. The controversy was, okay, can you use this information that's on Facebook to show that he's actually married or not married? Another case was with respect to.
I'm sorry, I don't mean to cut you. They actually used his marital status on Facebook.
Well, what he did was he claimed he didn't want to be married, so he claimed his marriage was void, and therefore he didn't participate in any bigamy. So therefore
his status,
he can't no, not the status himself, but just from the photographs.
Okay.
Yeah. So therefore there was no bigamy. You know, he didn't want to pay alimony. He didn't want to pay child custody. So, but they used this information that was posted on Facebook for this. The next case was a case with respect to another divorce case and child custody case. The wife actually set up a page on Facebook, posed herself as a 17-year-old woman, tried to court her soon-to-be divorced husband to show the court that he was unfit to actually be the father for their child, and this is how Facebook is being used in the legal context.
Was there any recourse to the wife, or I guess that sort of entrapment?
Well, it was entrapment, but what's interesting enough is the husband then knew it was the wife and used Facebook to engage her to show that he did not have any intent, exactly, to show that he had no intent to, to show her intent, to show the fact that she was trying to entrap him in order to affect who got custody of the child.